courts are considered to be temples of justice, and every court has inherent powers. Whatever may be stated in any law, the powers of the courts which are inherent operate to give justice to everyone. Sections 148 to 143b speaks about these inherent powers of the court. What is the meaning of inherent? Inherent means which is natural to a person or to a thing, a natural quality or a permanent quality or attribute which is there, which is intrinsic to that thing, and which is an essential thing, an essential natural quality which is vested in or attached to a person or office. Now coming to the first power, that is section 148, relating to enlargement of time. So the courts have the inherent powers. Number 1, enlargement of time. Section 148 says, any period which is fixed or granted by the court will be enlarged by that court, and the court has the power to enlarge that period even if the original period has expired. That means, suppose a person has filed an application and the court says that the time given or the period fixed to hear on that application is on such and such date, and the court says that it is a final date. Even though that original period expires, after that suppose he applies and says that he has sufficient cause that he could not appear before the court has a power to enlarge that period. So that this inherent power is there in every court, though it may be stated in any law that this is the fixed time, but the law itself provides that this power of the court to enlarge the time cannot be taken away from the court, but it is a discretion. From time to time, the court can enlarge such period, but not exceeding 30 days in total. This has been stated by the section 148. Then what are the conditions for this to operate? First of all, a period must have been fixed or granted by the court, and such period must be for doing an act which is prescribed or allowed by the court. In such cases where the court allows some time for doing that act, say for filing the written statement, or for hearing before the court, or for filing a certain application, or for providing some evidence, anything. So for that prescribed thing or an act which is allowed by the court, that period must have been fixed or granted by the court. That is the condition. Then the next discretionary power is, or inherent power we can say, is relating to payment of court fees under section 149. Now suppose a party files a suit and he makes the payment of the court fees, but there is a deficiency in the court fees and the time expires, that is whatever is the prescribed time of the period of limitation, that expires, and after that he does not have a right, suppose, and then he files an application to make up the deficiency of court fees. In such case, there is no such provision specifically stated, but section 149 says, for the purpose of allowing the party to make up the deficiency of court fees payable on a plaint or a memorandum of appeal, etc., even after the expiry of the period of limitation which is prescribed, that discretion is in the hands of the court, and this is the inherent power of the court which cannot be taken away. Coming to section 150, that is transferring of business. What is this power? Here section 150 says, where the business of any court is transferred to any other court, then the inherent power of that court, that is the transferee court, will exercise the same powers and discharge the same duties as this court which has transferred had. That means this power is transferred to the other court. This is section 150. Then this should be exercised for the ends of justice. Section 151 is a very, very important provision which saves the inherent powers of the court. The heading of that particular provision is saving of inherent powers of the court. It says that in this code, whatever we have said, whatever sections, orders, rules have been stated expressly in this code, they shall not limit the inherent powers of the court to make any more orders. So the court is not bound to make orders only according to the sections and rules. It can make any such orders which are necessary for the ends of justice, or it can make any orders to prevent abuse of the process of the court. So there are two things. One is for the ends of justice and second is to prevent abuse of the process of the court. What are the examples of these inherent powers? How can we say that these are the things which can be done by the court, which is not in the code? Here, it can recall its own orders. After passing an order, under the inherent powers, the court can recall its own orders. It can correct mistakes which has been done inadvertently, giving the or drafting the judgment or the order or any calculation. That is an example of inherent powers. Setting aside an ex parte order. If an order has been passed, of course there are sections which speak about ex parte orders, but besides that, any other order, the court has an inherent power to set aside according to its inherent powers. Then it can add or delete any party, that is the inherent power of the court. To hold trial in camera, it is a discretion of the court to hold trial in camera wherever it is required. Extending time to pay arrears of rent, that also is the inherent power of the court, and such other powers which are stated to be inherent powers which the court can pass orders upon. Amendment of judgments, decrees, orders and other records. So the other provisions which we see in this regard is amendment of judgments, decrees, orders and other records. These are also part of the inherent powers of the court. Section 152 says that either suo motu, that is of its own record, or after the application of any parties, any court can correct any clerical mistakes or any arithmetical mistakes in the judgments or decrees or orders which may be arising by some accidental slip or omission. So because of typing mistakes, or maybe because of an accidental slip of stating the order, or by erroneously or mistakenly pronouncing a mistaken word at any time, those words or those clerical mistakes or arithmetical mistakes which are there in judgments can be corrected under section 152. So a person may file an application for the correction, or a court may by itself correct. It has the inherent power. For example, if there is a calculation of the amount which should be paid as a compensation to a person, by mistake the clerical mistake happens and the court mistakenly calculates that wrongly. So later on, if the party comes to know, he can file an application and he can ask under section 152 to correct that. Or the court, if it comes to know that this mistake has happened, by its own it can correct these mistakes or arithmetical mistakes in the judgments, decrees or orders. Then the other provision is section 153 relating to judgments, decrees and orders again. 153 is a general power to amend. Suppose there is a some issue in a proceeding, and for determining that that particular issue, an amendment has to be done. So for that, the court may by itself amend any defect or error in that proceeding or the suit under section 153. Section 153A speaks about power to amend the decree when appeal is summarily dismissed. Where the appellate court dismisses any appeal summarily, the power of the court to amend under section 152, the decree or order which is appealed against, may be exercised by the court which has passed the decree or order in the first instance. That means who is going to amend, because it goes in appeal, and which is the court which can amend that. So the court which passed the decree or order in the first instance can amend or has the power to amend that particular decree. So even though by the dismissal of that appeal, the effect is that the decree is confirmed, or the court of first instance, whatever the decree has been passed, the decree has been confirmed in appeal. Even then, the court which has passed the decree or order in the first instance can exercise the power under 152 to amend the decree. This is the meaning of 153A. Then what are the limitations? Here there is a case, Arjun Singh versus Mohinder Kumar, which was decided in 1964. Whatever the court can do under these inherent powers cannot be all stated, and they can be exercised only when there are no express provisions in the code relating to those powers. For example, there is a provision of issuing commissions. So a commission is issued. Suppose a person applies under this provision. Suppose a person applies under 151 for establishing or for issuing a commission. The court cannot issue the commission under the inherent powers. Why? Because there is already a express power for that purpose. So only in absence of express provisions these inherent powers can be exercised, not when it can be exercised when there are already provisions. Thirdly, they cannot be exercised in conflict with what has been expressly provided. For example, if the code says that the commission can be issued only for the following purposes, that has been stated in section 75. Now, in conflict with that, the code cannot issue a commission for something else which is not expressly provided in the code, because then that would be in conflict with the provision in the code. Because when the code specifically says something, then the court cannot go against the words of the code or against the intentions of the legislature. Once the legislature has enacted something, the courts cannot exercise their powers against the intentions of the legislature. This was stated in Arjun Singh versus Mohinder Kumar. Section 153B comes to discuss of one more power of the court, that is in camera, place of trial to be deemed to be open court. What is this provision? Section 153B says that the place in which any civil court is held, that will be deemed to be an open court. That means for trying any suit wherever the court sits or which is the place, there generally the public will have access and it will be open to the public. This is a general provision, but there is a proviso that the presiding judge, if at that time he thinks fit, may order that at any stage of any inquiry before the court or when the trial is going on before the court of any particular case, may order that the public shall not have access to remain in that room or building used by the court, or any particular person shall not have access to be or remain in the room or building used by the court. This is the meaning of in camera proceedings. So normally the proceedings have to be in the open court, but if the presiding judge says or thinks that at this particular stage of trial, it may be a sensitive case, it may be relating to the character of a woman, it may be relating to a matrimonial case, or it may be relating to some matters which may not be proper to be stated in public. In such cases, the reasons are not given, but in such cases the presiding judge may make an order that the general public shall not have access and they shall not remain in that room or building, and they may be sent out. This is a in camera proceeding. This is provided under section 153B, which was also inserted by the way of amendment to the Civil Procedure Code. So, summarizing these provisions, we can see that section 148 to 153B of the code provide the courts with very wide and extensive powers to minimize the litigation, because the courts can have the inherent power to render full and complete justice between the parties before them. So, when the provision is there, or when there is an express provision, the court will not pass or use these powers, but these powers, that is section 151 specially, saves the inherent powers of the court, which are not been conferred but are inherent in every court, because the court has a duty to do justice to the cause. I hope you have learned something from this video. If you have liked it, please share it with anyone who you think would be interested. Please leave your comments and I would be happy to reply to them. Do subscribe to get more information on everyday law and legal studies. Thank you.